If you allege in your petition for adoption that somebody's consent who's required by law, that their consent to the adoption is not required, then you have to serve notice of adoption to that person, and they then have an opportunity to defend their position. You could allege in your petition for adoption that biological father's consent's not required because he's unfit to be a parent, but there's nothing that says that you have to serve that notice within a certain period of time. If DCS is pursuing an involuntary termination of either parent, then maybe you don't need to serve notice because DCS is going to bear the burden. Now, if you want to take care of parental rights under the adoption, then you would maybe serve notice to the biological parents alleging why their consent is not required. If you're fine with DCS pursuing the termination on their own, then let them do it. Don't worry about serving the notices of adoption. Serving notices of adoption in a DCS adoption could increase the cost of your adoption significantly. It would then trigger a contested adoption. And all of the litigation that was going to take place in the termination is now going to take place in the adoption.